2 of the House of Commons Standing Committee on National Defence. Pursuant to the order of reference of Friday, October 10, 2025, and the motion adopted by the committee on Thursday, October 23, 2025, the committee is meeting to resume its consideration of Bill C-11, an act to amend the National Defence Act and other acts. Today's meeting is taking place in hybrid format. Pursuant to the standing orders, members are attending in person and remotely using Zoom application. Before we continue, I ask participants to consult the guidelines on the table. These measures are to help prevent audio and feedback incidences to protect the health and safety of our interpreters. I would like to remind the witnesses and members, please wait until I recognize you by name before speaking. If you wish to speak, please raise your hand, and for members on Zoom, use the hand raise function. The clerk and I will manage the speaking order as best we can. And for interpretation, use your earpiece and select the appropriate channel, either floor, English, or French, also available on Zoom. Again, all comments should be addressed through the chair. I would also like to welcome our witnesses again, Colonel Genevieve Lautier, Deputy Judge Advocate General, Military Justice Modernization, Canadian Armed Forces, and Lieutenant Governor Colonel Matt McMillan, Director, Military Justice Implementation, Office of the Justice Advocate General, Canadian Armed Forces. Folks, we will now resume the clause-by-clause consideration of Bill C-11 that we were debating in regards to CPC 3 related to Clause 7. And I have two names on the list from last time. One is Tim Watchhorn, followed by Vivian Lapointe, and then Monsieur Sabat Tremblay. Mr. Watchhorn, over to you.
Thank you, Mr. Chair. Thank you for letting me intervene on this clause. We're at Clause 7, if I'm not mistaken, gentlemen. So I just want to put something on the record here. We've been talking about choice versus non-choice. Okay, for the last hour or so, that has been the debate. And I just want to bring an observation that I made by listening to the witnesses that we've heard over the past few weeks and just bring something to head because I think it's very important. So I'm going to do this in both languages just to make sure, you know, that my message is heard. The reason we've seen so many changes, and we've talked about this, we've seen changes in the military culture, okay? There has been progress made since 2021. But there's a reason for that. The reason is we ended concurrent jurisdiction in 2021. So all cases were sent to civil court. So undoing a system that works and reinstating concurrent jurisdiction would be a step backward, in my opinion, and would not do justice to all the survivors. We heard from several witnesses that a proposed choice is actually a false choice, and that by giving the civilian system exclusive jurisdiction over sexual offenses under the criminal code, what we're doing is providing legal clarity and certainty to everyone. And I think we should remember that. Donc, pour nos amis au Québec, la raison pourquoi...
For our friends in Quebec, the reason that we've seen an improvement in military culture over the last 4 years, and there has been an improvement, we've heard that from victims and certain witnesses, the reason is that there was an interim directive in 2021 that ended joint jurisdiction, or concurrent jurisdiction rather. So restoring that would be a step backward. It would not do justice to the survivors. We heard a number of witnesses saying that this is actually a false choice, and that by giving the civil system exclusive jurisdiction over sexual offenses in the criminal code, we would have more legal clarity and precision. So I just wanted to make that point. Thank you, Mr. Chair.
Thank you. Ms. Lapointe, over to you.
Thank you, Mr. Chair. I want to, as committee members, I want to commend the witnesses that came forward to us, arguably perhaps to talk about something that where they felt at their most vulnerable. And I think it's important that we we listen to those voices, all of the voices of people who've come forward, and that includes the members who came and met with Justice Arbor. And I'm reminded by the report and the recommendations in the Arbor report, which was only tabled in 2022. We had some debate last week at committee meeting that it was like a 10-year-old report. It was actually tabled in 22. And we know that the fundamental cultural shift that we needed to see at the Canadian Armed Forces can't happen over a 36-month period. And to me, the recommendation about moving it over to or moving it away from the military system is about removing the pressure and not necessarily survivors' voice. And we heard in the Arbor report from the people that she met with that survivors said they often feel subtle and sometimes explicit pressure to remain within the military system. And to me, a default jurisdiction, civilian jurisdiction system actually protects the survivor and not the institution. And so I think that that's very important. And so I just want to reflect on some of the discussion that we had at our last meeting. And to me, choice requires real equivalency. And despite some measures of progress, that full equivalency doesn't exist today, and we need to ensure that we're not going backwards. And so all of the voices that came forward, both at committee as well as those that met with Justice Arbor, I think need to be listened to and weighted in the decision that we make. Thank you, Chair.
Point. Monsieur Tremblay.
En fait, c'est une question davantage.
This is actually a fairly technical question. In a case where amendment proposals are passed and then would be deemed out of order, would the discussion then come back here and would we be able to rule on it?
Proceed, yeah.
Oui, merci. Je peux répondre à cette...
Yes, so I can answer that question. If this is the case of an amendment that the committee adopted, and then the report goes back to the House, if there are inconsistencies that are raised after that, normally we would see amendments at report stage and there would be the possibility to make corrections. For example, if the committee hasn't finished its clause-by-clause consideration and then wants to go back to correct any inconsistencies, the committee can do so with unanimous consent, so they can reconsider previously made decisions. So we wouldn't be condemned to these decisions lasting forever and ever if we did want to change them. Correct.
All right. Any more speakers on this issue? Yes?
Going back to the technical side, that there's nothing like we have right now that I know there's probably a few down that might be called that they're redundant or not necessary because of previous amendments that have been passed. That would we'd deal with that as we're going through here on the advice of the technical expertise brought forward by the legislative clerks. Correct? And then also the government still has the power, or anyone. Well, I guess it would be at report stage. None of the members would be able to bring forward those amendments at report stage in the House. It would have to be the government itself.
Normally, that is what we see, but any member has the opportunity at report stage to submit amendments for report stage.
Okay, because I thought there had been agreement made and standing orders adjusted to ensure that, because I know that used to happen frequently, and that, 2012 or 2013, we decided to allow members that weren't or weren't participating as permanent members of a committee to make amendments at committee, as we're doing right now with the NDP. That's how we've been able to get around that.
Yes, you're right. So that is as per the routine motions that the committee has adopted. That being said, in the case of any amendments, report stage is a further opportunity to submit amendments. But the principle that we go by is anything that could not have been submitted in committee can then be submitted at report stage.
Okay.
And then, but not necessarily selected by the speaker.
Okay.
Yeah.
Okay, thank you.
All right. Now we're dealing with CP3. We've debated it extensively. And I now call on the committee to discuss, and shall that clause CP3 from clause 7 carry? Should we put it to a vote? Okay, recorded vote.
Madame Romanado.
Nay.
Madame Lapointe.
No.
Monsieur Watchhorn.
No.
Mr. Mallette.
Nay.
Mr. Bezan.
Yay.
Ms. Gallant.
Yay.
Mr. Anderson.
Yes, I support Joyce.
Mr. Kibble.
Yay.
Monsieur Savard-Tremblay.
Oui.
Yeas pour 5, nays contre 4, 4.
Clause carried. Clause 7 is carried. We're going to clause 8.
CPC3.
Oh, CPC3, sorry, CPC amendment to clause 7. Thank you for that. Okay. Now, do we need to deal with NDP, or it's all the same, right?
Yeah, so
And clause 7, so we're now,
So if CPC3 and
right. So, yeah, given that CPC3 is moved, NDP1 cannot be moved as it is identical. Now we're back to clause 7. Should clause 7 carry
as amended.
as amended with CPC3? Should we vote on that one? I mean, we're on division? Okay. Put forward the vote.
Okay. So, on division. Madame Romanado.
Nay.
Madame Lapointe.
No.
Monsieur Watchhorn.
No.
Mr. Mallette.
No.
Mr. Bezan.
Yes.
Ms. Gallant.
Yay.
Mr. Anderson.
Yes.
Mr. Kibble.
Yay.
Monsieur Savard-Tremblay.
Oui.
Yeas pour 5, nays contre 4.
Now we're on to CPC4. Would the member like to move? Pardon me?
Will not be moving.
You will not, okay.
PC 5.
Before that, okay, by all means.
Okay, so I'll move CPC 5 as circulated. I won't bother reading it. It's there for everyone to see. I'm sure everybody's had a chance to study it. And I'll just speak to that, so CPC 5 again comes down to making sure that we have choice in the system, especially as it comes down to the investigative side. This provides the ability, again, for the military police, the military, or the Canadian Forces National Investigative Service to, again, restore the ability under choice at the direction of the victim to pursue military prosecution rather than a civilian prosecution. And again, I'll just say that you know, we read a lot of this into the record. But just you know, Tanya Couch said, removing the CAF's authority to investigate sexual offenses would do a disservice to serving members. A more balanced approach is to establish concurrent jurisdiction between the military and civilian systems for reports of sexual assault. This model would preserve choice, allowing victims to decide whether their case proceeds through military or civilian channels, and agency the ability to make that decision freely with informed support and respect for victims and that autonomy.
Thank you, Mr. Bazan. Now, folks, if CPC 5 is adopted, NDP 2 and CPC 6 cannot be moved due to line conflict. And as the House of Commons Procedure and Practice, 4th edition states in section 16.71, amendments must be proposed following the order of the text to be amended. Once a line of a clause has been amended by the committee, it cannot be further amended by a subsequent amendment, as given the line may be amended only once. Open for debate.
I don't know who's on the list.
Who do we got? Ms. Lapointe.
Thank you, Chair. I'd like to ask our witnesses what the impact would be on this amendment in practice within the military justice system, but also on the operational effectiveness of the Canadian Armed Forces.
On that one, there's some issue like we have discussed previously. This one, we're addressing investigative jurisdiction. So with all due respect, that's one that it's difficult for us to understand kind of the wording, the way it's heading together. So the purpose of the clause was to remove the investigative jurisdiction. What we understand is that that part of the provision would be repealed and will keep like the other two. But the way the act had been drafted was C11 was drafted, 70.1 was removing it, and the other two other following provision were there to explain in which circumstances in case of emergency, to preserve evidence, to make sure that someone was not running away and nothing could be done by a Canadian Armed Forces member. So the three were really written together. So now with the provision removing, so we're not removing anymore the jurisdiction. That's what I understand from the reading of the provision. But the rest still continue to read like they can do something until the civilian police or civilian authority arrives. So it seemed unclear who has where it's going to go. If they don't come, does it mean that it's going to stay in the military? So with all due respect, it's a little bit unclear.
Okay. If we can talk more about that last point you just made, because it's my understanding that the bill, the way it is currently written or drafted, keeps the military and the civilian roles very clear. So if you can confirm that for us. And then a follow-up question is, what problems could arise should those roles start to overlap?
So you're right that the bill, the way it was drafted, was really to implement Justice Harbour Recommendation 5, that is to remove the jurisdiction at investigation and prosecution stage. So that's such amendment would maintain, so that would be contrary to the recommendation of Madame Harbour. Every time that there's a lack of clarity in the system of the military justice system is really there to maintain discipline, efficiency, and morale of the Canadian Forces and the operational effectiveness. When you enter an area that may be a gray zone and it may not be clear, that's always a risk for the system to not be used, to not be understood properly. And when it's not clear on jurisdiction, there's always that someone could exercise it, but the conclusion could be that someone may not have had the jurisdiction. So that's always could be a challenge.
In your response, you said that this proposed amendment goes against Arbor's number 5 recommendation. Can you speak to the importance of that recommendation in terms of within the CAF system?
So the recommendation of Madame Harbour, our recommendation, the argument behind that was really to clarify the system between one system or the other one, to really give clarity to a victim where they're going to go, to know what it's expected, what is clear instead of going from one system on the other one, in the things that may be uncertain on them, and bring kind of further stress considering the challenges they're already living through.
Thank you.
Thank you. MP Idlout is online. Your hand is up.
Yes, Ulla, good morning. I realize that we can't discuss a later amendment, but given that my NDP2 would be impacted by if CPC 5 passes, I'm just wondering if we could ask this just for a clarification on.
Il n'y a pas d'interprétation, Monsieur le Président.
Leave NDP, your NDP2, if is similar. So we won't be able to move yours, depending upon what happens with CPC 5. It'll be dependent upon
Right. So the part where NDP2 is separate from CPC 5 is regarding the approval of what we did for CPC 3, which was exactly the same as NDP 1. NDP 2 is different in that it would make an amendment to the act which allows the victim to choose the system for their case, which was approved in CPC 3. So I see that's where it's different, and I wonder if the witnesses can respond to that.
Sure. I mean, you can speak to CPC 5, and I think there's a question to the witnesses regarding the similarity or in regards to NDP 2. There will be a line conflict should that one be adopted, mind you. Are you asking the witnesses or are you asking the clerks, the legislative?
I don't know which ones are the experts. In the case that there is a topical difference, then hopefully I would like to submit a sub-amendment if the Conservatives agree to CPC 5.
Did you want to clarify? Just a moment, please. Yeah, so you're dealing with the issue with CP5 is that we're dealing with the same line, but so we can't if we can't move to the line conflict, but you can do a sub amendment to CP5.
Yes, so I do want to propose a sub-amendment to CPC 5 using the same language that the NDP submitted in NDP 2 regarding by replacing line 35 on page 5 with the following, and then to continue that language. I don't know if I should continue that language because I haven't had the chance to submit the amendment yet.
Mr. Dowd, we need that in writing.
Okay, so because I didn't know that this was going to happen with my NDP2 being at risk, I do want to send a quick email in writing because it is related to language that's already in the package. It's not new information necessarily.
Can you do it quickly? And it's suspend for about a minute or so?
Yes.
While we're on suspension, just if I could ask the legislative clerks if you could just clarify why, if CPC 5 passes, why would NDP 2 be ruled out of order? What is the legal reason? Actually, yeah, because line 37 disappears after line 36 disappears, right? Just want to make sure.
Not yet. We're not suspended yet. But Ms. Sedal, if you can get your thing in writing as we speak.
Est-il clair également qu'on souhaite avoir le sous-amendement?
We also would like to see the sub-amendment in both languages.
Languages, Ms. Adele, please.
Yes, my staff, Christine Ackerman, will be sending to your clerk ASAP.
Mr. Bazan, we're trying to get a clarity here for you.
An answer. Yep.
We're not suspended yet.
Not yet. Just if I can get an answer.
Ms. Adele, we're just reviewing, and in response to Mr. Bazan's question for clarity, by replacing line 37, it eliminates what you have on your amendment. If you wish to then just resubmit a sub-amendment to highlight the verbiage that you put under item B, that would suffice. And then we can move forward with your sub-amendment to determine if the will is there to adopt it and then go forward with the amendment, SCPC 5.
Okay, thank you. I do understand. And just very quickly, the way to pronounce my last name is Idlout with an L.
Idlout. My apologies.
Idlout. That's okay.
Idlout.
Idlout, yes.
Monsieur Savard-Tremblay, it's in both languages already. Yeah, I think we can probably proceed without suspension.
Mais il est où?
But where is it? Where is it?
Oui, mais sous forme de sous-amendement.
I'm going to suspend for a moment so that we can get this clarified. Suspend. Unfortunately, you're not a member of the committee, and you can't move sub-amendments. You can, in this case. So I'm going to proceed with ongoing debate with regards to CPC 5. Mr. Mallet, over to you.
Monsieur le Président.
Sorry?
Juste avant,
Chair? First, I just want to understand that there was a written version here, but when we get a sub-amendment, it would be good to get it in both languages. So we had to understand that, first of all, the first part was going to drop and the second part was going to be applied. So it wasn't just exactly what we had here in front of us that was going to be applied. So anytime that there is a sub-amendment, I would like us to be able to suspend and get, the exact text in front of us in both languages.
All right. Well noted. Mr. Millet and then Ms. Bazan, is in regards to this very issue?
To move the amendment on behalf of Ms. You're going to do it?
Mr. Millet?
Then I'll move the amendment. I can't either?
It's your amendment.
Oh, right. But one of my team can? Yes.
Mr. Millet?
Questions for the witnesses?
Yeah.
Well, procedurally, are we going to allow that to go first, or my questions?
He can't move a sub-amendment, and now they're debating it. I pass it over to you, Ms. Millett.
Thank you. All right. Thank you, Mr. Chair. My question is for both Colonel Lortie and Colonel McMillan. As I read this, this motion would delete the removal of the CAF's jurisdiction to investigate CCSOs contemplated under Bill C-11. So, therefore, military police would retain investigative jurisdiction as I read this amendment. So the follow-on amendments would appear to limit investigative jurisdiction, given the possible obligation to transfer evidence, etc. So does this revert, quite simply at the end of the day, this, as proposed, CPC 5, this deleting of line 36, replacing with the following, does this revert the investigative and the prosecutorial system to basically where we had it prior to 2021?
So the provision, as we read it, maintain Canadian Armed Forces jurisdiction to investigate. That provision is not related to the prosecution. It seems to be related to the investigation. But the doubt it keeps is that they allow a Canadian Armed Forces member to exercise jurisdiction, but if I read one of the provisions, it says before the arrival of the civilian authority having jurisdiction in the matter. So it seems to portray that a transfer could be done, but we don't have a provision that states exclusive jurisdiction on one or the other, who has primacy one way or the other. So it doesn't appear clear when we're reading it, with all due respect to the provision that is presented.
Colonel McMillan, do you have anything further on that, or?
I would just say, if you look at 70.1 sub 1, in addition to what Colonel Lortie said, the first portion indicates that the military police may exercise their jurisdiction before the arrival, but after that it says, to the extent necessary to prevent the commission, continuation, or repetition of an offense referred to in Clause 7. So the concurrent jurisdiction piece is only for a little piece of time. So that goes to the lack of clarity in the overall provision that as we read it.
Okay. One further question. What are the other criminal code offenses military police can investigate and prosecute at this point? The criminal code.
Jurisdiction on every offenses. That's the only clause that purport to remove some type of jurisdiction. And even before the situation of in 1999, when the court-martial gained back the jurisdiction to try sexual assault, the military police and Canadian Armed Forces had kept the jurisdiction to investigate. So it had never been removed in that time frame. At that time, it was only a question of prosecution that could change. Here would be those only offenses. Military police and Canadian Armed Forces member have jurisdiction to investigate all the other offenses. There's no limitation anywhere else in the under the National Defense Act.
Thank you, Mr. Chair.
Monsieur Savard-Tremblay.
So I won't call it NDP 2, but the sub-amendment that was proposed, so the second half of NDP 2 here, since Ms. Idlout cannot move it, I would like to move it. So I'm moving an amendment to CPC 5, which is equivalent to NDP 2.
Okay. We all understand the sub-amendment? Further debate on the sub-amendment? We have to vote on this amendment, sub-amendment, I should say. Putting it to a vote now.
Madame Romanado.
No.
Madame Lapointe.
No.
Monsieur Watchhorn.
No.
Mr. Mallette.
Nope.
Mr. Bezan.
Oui.
Ms. Gallant.
Yes.
Mr. Anderson.
Yes.
Mr. Kibble.
Oui.
Monsieur Savard-Tremblay.
Oui.
Yeas pour 5, 5, nays, contre, 4. 4.
This is a sub-amendment from the BQ, from the bloc, as it relates to the submission made by Monsieur Sauvat-Tremblay. We are now back to the amended amendment. Any further debate? Mr. Watchhorn. Or, I'm sorry, Ms. Gallant is first, and then Ms. You okay?
He took care of it.
Mr. Watchhorn.
Avoir un petit peu de clarté là.
Hoping to get a bit of clarity here. Earlier, with Article 7, we were talking about the choice of the court. Now we're talking about the choice of the people who are going to be leading the investigation. If a person decides that their case should be treated by military police, does that, then with this amendment, does that automatically mean that it would be military investigators who would take charge of that? And same thing, if the person decides to go with the civil court, is it clear to you that the investigators will be from the civil system? Or could it be either or? Once there's a question of jurisdiction, it always depends on the person who has the authority, who has the discretion. So whether it's military or civil, it is that person who will decide. Because there are other aspects of jurisdiction that could enter into account, and the case could go to one jurisdiction or the other. If I've correctly understood the last sub-amendment that was made, or the last change that was made about victims' requests, it says this victim asks under paragraph 70, sub 2, that the person be judged by a court-martial. What you need to understand is that at this point, you would be at the beginning of an investigation. You don't necessarily know what evidence is going to be presented. We don't necessarily know whether accusations will be made, and if so, what they will be, what the nature of them will be. So we don't know exactly what provision would apply. So this is very early in the process. But then we're already talking about a court-martial, so saying that the person be judged by a court-martial. But at this point, you can't have all of the aspects because it's the very beginning of the investigation. So it may take a long time before we would be able to decide whether all of the knowledge of the offense is there to be able to bring charges under a particular provision, so either the Criminal Code or the National Defense Act. So that those can be quite different. So when the victim files a complaint, they don't know if they'll be dealing with military investigators or civil investigators dealing with that case, if we pass this amendment. So it's a question of discretion and deciding which system would move forward to do the investigation, yes. So it seems to me that that might lead to further confusion for victims. Well, it was previously said that that might lead to a false impression, right? That might lead the victim to believe that it would be one system or the other. So yes, that could be a difficult or confusing choice for a victim.
Good. Mr. Bazan.
On, I think what we're doing here is putting back in concurrent jurisdiction, because that has been removed from in Canada or domestic charges under the Canadian, anything that happens in Canada on a base with the Canadian Forces, or even off base for that matter. Canadian Forces would lose the ability to investigate. All evidence have to be turned over to civilian authorities. And as we heard, over and over again, is that victims wanted choice. The survivors told us clearly at committee that they wanted choice. Overwhelmingly, they were asking for choice. And, you know, in a written submission from the Barreau du Quebec, they said, considers that it would be appropriate to resolve these challenges by amending the bill so as to give victims the choice to decide which system would be best for them, given the circumstances of their situation. And again, I'll quote General Hanrahan, who is the Provost Marshal General, said that at any point in the process with concurrent jurisdiction, there's an ability to have a choice change. A victim, for example, in the beginning may ask for a military police investigation or vice versa, a civilian police investigation. And during the course of that investigation, they may change their mind and ask for something different. Concurrent jurisdiction allows us, from an investigative perspective and prosecutorial perspective, to work with the victim to help them work through those choices at any point along that process. And if we don't amend this section of the Act, then again, that choice is removed and everything is put in the hands of civilian authorities, and the military police and the National Investigative Service are unable to carry forward with any investigation because it is being removed. So I ask everyone to support this amendment as amended by the Bloc and the NDP.
Remenado.
Thank you, Chair, and through you, I'd like to thank the experts for being here again today. I just want to make sure that I'm understanding correctly. This amendment would have the effect of concurrent jurisdiction. So in the example that you gave, you talked about it, for instance, that an event had happened. Immediately after that event, the victim, goes immediately to whoever's in the vicinity and says, this is what happened. Because this would allow for the military to investigate while waiting for the civilian police to arrive, if they were to arrive. There's some confusion about chain of evidence in terms of who has the jurisdiction, if I understand correctly. I'm not a police officer, so I just want to make sure I'm understanding correctly. But I also understand that confusion over who is actually going to take the lead on the investigation, it could move back and forth. And I recall that on November 20th, we had a witness came forward, Paula McDonald, who came and she said, and I quote, "When I went to the civilian police, I was told more than once to go back to the military system that failed me. At the same time, my leaders reframed my complaints. Instead of naming sexual harassment and abuse of power that led to sexual assault, they called me emotional, hypersensitive, and a mental health problem. In my case, the Canadian Armed Forces didn't simply mishandle a file. It used the machinery of the military justice and grievance system to protect its membership, who violated the National Defense Act and silenced me. The misuse of state power that the Charter is meant to guard against is what they did. It is exactly why the reforms like Bill C-11 and a real shift to independent civilian jurisdiction over sexual offences is so urgently needed to maintain the rule of law within the Canadian Armed Forces. If a Canadian solution is to move it to the civilian system, and it seems that this is our Canadian solution, where our 3 Supreme Court justices who are expert in the delivery of justice say it should be, then this is where we need to go do. So we've heard that the confusion about who is actually investigating, who is prosecuting, even in this amendment, can add to a victim's confusion in terms of, am I making the right choice choosing this system or another? And also, if they start with jurisdiction with the military, for instance, the police arrive, civilian police arrive, then ask the civilian police to take over the investigation. Could that not lead to confusion, and also in terms of the ability to get a prosecution because of the movement bouncing from one jurisdiction to another? I just want to make sure I'm understanding what the impact of this amendment is.
There's some uncertainty while reading the text itself, because the first 70.2 and 70.3 were really written in C11 to, because one provision was removing jurisdiction, the other 2 were a safety net to ensure that nothing was falling into the crack, that the evidence could be transferred and there were no issue. And we didn't want, if someone was in danger or something was happening, that a Canadian Armed Forces member could act and could not just be there and do nothing. So that's really the way C11 provision of 70.2 and .3 were drafted. By removing the exclusion of jurisdiction, meaning the way I understand it, that it proposed concurrent jurisdiction. The wording on it is still referred to until the arrival of the civilian authority having jurisdiction in the matter, but it's really limited to some topic of preventing the commission, continuation, or repetition, and not the full investigation. So that's really kind of a limited wording. And the only time where we get to the victim that requests something, it's really at the point where the transfer is to happen, because initially it was written that it's going to the civilian. Here it's unclear who has the first jurisdiction from the civilian or the military. So if you have the request that the person be tried by a court-martial, as I mentioned previously, we were early on. It can be the first event that just happened, and someone claimed that something just happened, and a CAF member is there, would run after someone. Want to be careful. I understand it can be difficult for people to hear that. Someone is somewhere, say, I've been raped, there's someone running away, you want to get someone behind them because you don't know who it is, you want a CAF member to be able to act, get to the person, and the way it was written was you get to the person, you wait, you call the civilian police, and you transfer. Now, when we get to that point, it's the to be tried by a court-martial. But to be tried by a court-martial, you need to know which offense. You don't necessarily know all the other circumstances of the case, that what will be the offense that will be there. You're early on. We need to establish all the elements of the offense to lay a charge. So you're early on. We may not know at that point who will have jurisdiction on which offense will be laid. We're really kind of two separate steps of the process.
So in the example you just used, a Canadian Armed Forces member chases after the assailant, stops the assailant, does what? Calls the civilian police, calls. What would happen, and what would be the impact?
So the provision as amended says that they can stay there and keep the person, so they to stop the continuation of the offense, and it's related to waiting for the civilian authorities to arrive. So it seems to give, like, there's still a perception that civilian authorities should be called in, but later on, before the transfer of that person could be done, that's where we now had that the victim could request that the person be tried by a court-martial. We don't know about which offense.
So you can imagine if the members here are confused about the application of this as amended. Can you imagine what it would be like for an assailant? Someone has just been assaulted, has now running away. We have a CAF member chasing after the person. Not sure, am I supposed to chase after him? Am I supposed to call the police? Am I supposed to take care of it? There's a lot of confusion here, and I think this amendment actually adds to that confusion. Would you say that's correct? Thank you.
Over to you. And then Monsieur Sabat-Tremblay.
One moment, please. Yes, thank you, Chair. I would like to, further to my colleagues' observations and comments, I'd also like to draw our attention to some of the witness testimony from November 6th, at which Charlotte Duval-Lantoine gave the following observation. I want to underline, this is her comments here. I want to underline what Madame Arbour said about recommendation 5. That is the fact that giving the choice to victims to choose the jurisdiction in which they find themselves puts them in a, quote, in an untenable position. If the case doesn't go their way, then they find themselves re-traumatized with the possible question, did I make the wrong choice here? That creates severe psychological distress to the victim. My question, I guess, for our witnesses today, it seems to be the underlying theme is to minimize the trauma on the complainant or the victim in these cases. And Ms. Duval-Lantoine's testimony is further to Madame Arbour's recommendations to minimize that and make it a clear delineation of where the case would go. Is that my interpretation?
It was clear by Madam Justice Arbour at the outset that the purpose with going with one jurisdiction solely was for clarity. That was the understanding. When we look at the clause as amended, the purpose of 70.2 and 70.3, it's not required if you don't have 70.1. So 70.1 removed jurisdiction of military police. 70.2 and 70.3 created exceptions to that lack of jurisdiction, I'll call it in extremis, at a very outset until the arrival of civilian police. If you remove 70.1 from Clause 8 and leave 70.2 and 70.3 with the language that's in the bill, irrespective of the sub-amendment, it creates a lack of clarity. So where there is a lack of clarity, that could possibly result in the functioning of the military justice system not happening. We talked about choice at the outset of the victim choosing who would investigate. The language in 70.1 sub 1 and sub 2 right now. So the new, what was 70.2, doesn't speak to choice. It speaks to the military police, in theory, operating up until the point of civilian police arriving. If you look at the current 70.2, which as proposed, despite any other provision of this Act and any other law, an officer or non-commissioned member may secure or preserve any evidence of or relating to the offence referred to in subsection 1 before the arrival of the civilian authority having jurisdiction in the matter, avant l'arrivée des autorités civiles compétentes.
Before the arrival of the competent authority.
Military police are acting up until the point that the civilian police arrive. So it creates a question of you remove the clear clause, which is 70.1, that says you don't have jurisdiction, and leave the clauses, the subsections in the bill that were only intended to provide clarity to what was 70.1 in certain circumstances. So if you remove 70.1, 70.2 and 70.3, create a situation that's unclear. Where there's a lack of clarity, there's the challenge that the system will not function, and there will be questions about who has primacy of jurisdiction in the matter.
Which I would suggest further goes to Madame Duval-Antoine's observation that this would almost in another way re-traumatize the victim because of the lack of clarity in the process. When, as we know, the victims in these cases are traumatized in almost all cases to the point where the confusion is massive. They need clarity. They need to see a clear path to righting this wrong. Am I reading that correctly?
Behind Madame Arbour's recommendation to bring clarity, to remove the burden of a choice when someone could not necessarily understand both systems, the impact of a certain way or the other, and not knowing what decision will be taken and what are the impact on each step that could lead to something that unfortunately a victim may be re-traumatized later on considering. So that was really the underlying purpose of Madame Arbour's recommendation.
Thank you. Thank you.
Just very quickly, I think that the considerations raised are very relevant, but my BQ1 amendment, I think, will clarify all of this and allow us to avoid some of those gray zones that were raised, notably by Ms. Romanato.
Any further debate? We are now at CP5 as amended. Put it to a vote.
Madame Romanado?
No.
Madame Lapointe?
No.
Monsieur Watchhorn?
No.
Mr. Mallette?
No.
Mr. Bazan,
Yes.
Ms. Gallen,
Yes.
Mr. Anderson,
Oui.
Mr. Kibble,
Yes.
Monsieur Savard-Tremblay.
Oui.
Yeas pour 5, 5, nays contre 4, 4.
CP5 as amended, sub-amendment is carried. That references NDP2 and CPC6 irrelevant in this case. So we'll move on now to CPC BQ1. Over to you. Do you wish to move it, Mr. Savard-Tremblay?
Oui, ben écoutez, je crois que vous l'avez.
Yes, so I think that you all have it. I think it's fairly clear, but of course, if you have any questions, I'd be happy to answer them. But I think that this will actually sort out a lot of the concerns that were raised and some of the objections that were raised concerning the previous amendment.
As it's been adopted by CPC5, and as already discussed, there's an issue of coherence, right? That's arisen. And I will just advise that we shall proceed to have a debate. Mr. Ramanado.
Monsieur le Président,
Mr. Chair, I just want to check. Could you tell us if this amendment would lead to any possible delays? I'm thinking about the Jordan principle. So could they lead to delays, and if so, why?
Donc, comme on l'a mentionné,
As we said earlier, when you go toward one system and a file gets transferred there, there is a risk of delay. There is a risk that you end up at a point where the delay is unreasonable, and there could be charter applications made if that 18-month threshold is passed. In the military system, it can be 18 months or 12 months, depending on the type of case. And it's usually 18. So when you take a case that needs to go to the civil system first and needs to go through a certain number of procedures, and then if that case is transferred, it needs to be withdrawn. If it's before the courts, it requires the permission of the courts after the plea. So it depends, at what stage of the process this question is asked, but the prosecution would have to withdraw the charges under this motion. So this is, again, in the civil system. The charges would be withdrawn. The case would then be transferred to the military system. The military system would have to acknowledge the case, see if there is enough evidence to bring charges. Because on the military side, only certain authorities can bring charges. The civil police does not have the jurisdiction to do so. So we need to give the military police the file. They need to review it, get the necessary legal opinions, make a decision as to whether charges will be brought, and then they need to refer it to the Director of Military Prosecutions if it's going to go to court-martial. And the DPM then needs to decide if there will be those charges laid in order to send the case to court-martial. So when we're talking about a decision made in one system first, which is subsequently transferred to another system, certainly that can lead to the risk of delays. And in this example, when does the timer start? Is it as soon as accusations are brought forward, or when? In terms of the reasonable delay within the court system, there are certain delays that can count before accusations, but generally it starts when the accusation is made, and that applies to both systems, civil and military. Then there are also considerations about detention and parole. So certainly the person accused could face delays, but really the time that we're looking at is when the accusations are made, and that's within the civil system. And then even if the case was later transferred to the military system, it would be the first time it was filed in the civil system that would count as that. Like, that's when the timer would start for the 18 months. And when it comes to Jordan arguments. So 18 months, including a transfer from one system to another, I mean, the result could certainly be that the Jordan principle, or the Jordan ceiling rather, would not be respected. That is indeed a possibility when you have different actors in two different systems and a number of different stages that needed to be passed through. Indeed, there is a risk there of delay. And if the accused didn't see the case resolved within 18 months, what would be the result? Well, if there is an unreasonable delay, what we've been seeing is that there are stays of proceedings ordered by the courts. So if the victim starts out in the civil system, then at some point decides to transfer to the military system, and if the whole process takes more than 18 months, the accused can walk free, essentially. Well, yes, a stay of proceeding means that that would be the end of the proceedings, so there would be no further determination of guilt or otherwise. That would be the end of the proceedings, and things could not go further. But if I can just add, when we're talking about transferring a case from one system to another, the court-martial has its own jurisdiction, so it would decide if it has jurisdiction or not. So for another court to decide that it has jurisdiction, you know, a provincial court versus a court instituted under the National Defense Act, I mean, I would have some reservations about that. I don't think that one court can decide for another whether it has jurisdiction, because other courts do not have jurisdiction over the court-martial. Or, you know, as the case proceeds, the investigator could decide not to bring charges because their reading of the cases and the legal opinions could lead them to decide not to do so. So in that case, the case might not decide because the public interest might be in conflict with the case proceeding. In that case, if the victim wants to transfer, so it withdraws the case from the civil system, and then the military system decides not to pursue the case, can the victim then go back to the civil system? I'm not sure. Probably at that point, new accusations would need to be brought forward, but I'm not sure about that exact provision of the law. Certainly, it would lead to additional delay. So if charges were withdrawn, they would have to be brought forward again. Thank you.
Mr. Savard-Tremblay.
Mr. Savard-Tremblay. Yes, unfortunately, you know, there is no perfect world when we're dealing with cases like this. But I think this is kind of the least bad option. You know, it gives a certain amount of latitude to civil authorities to decide whether the case should be transferred or not. And also, we need to find a way to deal with the backlogs in the civil courts. Otherwise, there would just be a huge problem. But, for example, if a victim felt intimidated by the chain of command in the military system, for their case to be transferred to the military system, well, the civil court would need to be able to say, no, we're not going to transfer it. That's kind of the idea behind our proposal, to give a bit of leeway to the civil courts to avoid some of these issues that have been raised when we were talking about the previous amendment, or sub-amendment, rather.
Thank you, Mr. Savard-Tremblay. Monsieur Watchorn, and then Mr. President.
Merci. Donc, comme on peut voir, c'est clair comme l'autre.
So, you know, this is clear as mud, I guess. I think there's a lot of confusion. I think that the amendment, BQ1, actually goes against the spirit of CPC 5, which we just passed. The argument there was to have the option to have a case heard by either the military or civil systems. And what we're proposing is having the option of transferring it to the military one. With some safeguards, yes. But the first line is
civilian police with no exception. Après ça, il y a certains cas spécifiques qui pourraient être.
Then there are a few specific cases and exceptions that could be treated with. So that's complicated, but I would just bring up one point. Today we're talking about clarity. Even inside this committee, I think we're not totally clear about how this is going to move forward. Now, in June 2024, there was a report done by the Veterans Affairs Committee. They had a specific recommendation that they made in 2024, in June. And all parties supported this recommendation. It was recommendation number 40. I'll read it.
He says that the Department of National Defense, in accordance with the many recommendations made in the wake of Deschamps, Fish, and Arbour reports, establish a reporting mechanism outside of the military chain of command, provide victims of military sexual trauma with safe and confidential legal resources, and transfer the jurisdiction to investigate sexual misconduct and prosecute its perpetrators to civilian authorities. Moi, je vous soumets aujourd'hui là, que le.
So I would submit that the simplest thing we could have done would be to follow recommendation 5 made by Justice Arbour and simply transfer criminal sexual abuse cases to civil cases. Would you agree with that? Or civil courts, rather. The way the bill was written, it really, the goal was to put forward that recommendation by Justice Arbour. In terms of the implementation, the goal was to not have both courts doing investigations and prosecutions. Now, Section 7 was modified. There is some jurisdiction in terms of going to the courts. Section 8, or rather Clause 8, was changed, where we're talking about waiting until the civil police to arrive. And so I'm trying to see if this comes before or after the other provision. But so there's an investigation. We're waiting for the civilian police. At some point, the victim could ask for the case to be transferred to the military court, so that option exists. But we're still at the investigation stage. So here, accusations have been filed. We're already in an established system. We're before the civil court, and now the victim can ask. Well, actually, I'm not sure who would make the request, but there would be some sort of mechanism to allow the victim to make a request. But, exactly how is this request made, that remains unclear. But there would be a civil court that has civil jurisdiction, but doesn't have the court-martial's jurisdiction to determine the jurisdiction of another court. So there are often questions of jurisdictions that go to appeal, and then there is a court of appeal that rules. So there is the court-martial court of appeal, but here we're talking about a civil court deciding. So we're talking about one side sending a case to another side. That certainly raises questions about how that would work. So it's dysfunctional. Well, it raises a lot of doubts, and whenever there are doubts about how the system's going to move forward, some of the first people who have cases raise challenges, and then depending on those decisions, it may go to appeal. It may be dragged out over a number of years. If there's a court challenge, then the civilian appeal courts need to decide. There are similar appeal courts on the military side that are a bit different. But really the question is, before we even have clarity, how do we interpret the provisions as a whole? That could certainly take time. And the risk is that the system might not be used, that people would find other avenues So we want to have, the discipline and efficiency and morale of the troops, of our Canadian Armed Forces preserved. That's very important. And I think there are a lot of risks there.
Thank you. We have Mr. Bazin and Mr. Mallette, and then hopefully we can go into a vote at that point. Mr. Bazin?
Yeah, so just again, hearing from witnesses, and Christine Wood said at our 15th meeting of this committee, said I originally completely opposed the transfer of all cases to civilian court, and that was for 3 reasons. Number one, it's broken. So talk about the Jordan framework. That's one of the reasons not to put it in civilian court. Number 2, it offers victims no choice. Number 3, I believe the CAF has to maintain control over its jurisdiction and demonstrate it can be responsible for fixing its own harms. We also heard over and over again that, and I think this is what BQ1 does, is that it deals with the issue around the minor offenses that the civilian court isn't even going to want to pursue. And so even if we haven't been amending this bill and putting back in choice to the survivors of military sexual trauma, that the lower level cases, as we heard from Justice Deschamps when she was here, that they probably won't even be heard in the civilian court. They're going to be thrown out, and then there isn't no recourse within the court-martial system to deal with these other cases. We heard from the Director of Military Prosecutions, Colonel Kerr, who said, if it wasn't for the tabling of Bill C-11, I would already have rescinded my direction to stop exercising jurisdictions in these cases, and I'm fully prepared to resume accepting appropriate cases in the military justice system now. So we have to give the choice back to the victim, and they should have that at every stage of an investigation and during prosecution. And so in this case, if the civilian court is looking at it, and this is what the Block 1 Amendment will do, saying, there's no chance that we're going to even have the ability to deal with this. It's a low-level sexual offense. Then they can make that decision and fire it back into the court-martial system. I think it is the appropriate process to take.
I believe, Mr. McMillan, you have your hand up, and then Mr. Mallette, and then over to you, Mr. Tremblay.
Mr. Chair, I just want to provide some clarity. If this happens in relation to what the civilian court will only have jurisdiction over a matter if charges have been laid in the civilian system. So there would already been a determination from the prosecutor that they are going to proceed and lay charges. So they would have made a determination at this point that they have a reasonable prospect of conviction and there's public interest in proceeding. They would lay charges and then the matter would go before the civilian court. So that is one clarity in relation to that piece. The other thing is there is, as Colonel Lortie said, the question of who is going to bring the matter before the court. The prosecutor themselves, they are responsible for the societal interest of pursuing a matter in front of that court. The victim does not, in and of itself, have standing before that court. So the prosecutor, if there was a question about the victim not wanting to proceed in the civilian court, ultimately what would likely happen is they would request that from the prosecutor that they don't want to proceed. And it would be, again, it goes back to prosecutorial discretion. Given the new information, do they want to proceed on that path? If there was an application before the court, there's a question about how that would happen. Ultimately, the defense counsel at that time and the accused would be able to make representations on their own behalf as to whether they want to make that happen. So there's a lot of a lack of clarity in terms of exactly how that process would unfold. But at the outset, the charges would be laid in the civilian system. Otherwise, there's no determination in relation to that court to make that based on how it is drafted.
Thank you, Lieutenant Governor. Colonel. Mr. Mallette.
Thank you, Mr. Chair. I'll withhold my comments.
Mr. Tremblay.
Juste très brièvement à propos.
Just very briefly on this issue of delays. I don't think that a civil case should get a case and not expect delays, but if you look at the text of the amendment, it says, 70.11.1, last sentence, talking about the civil courts. They could decide that a court-martial should have jurisdiction if the court is of the opinion that it would not interfere with the popular administration of justice. So it's already in the amendment. If there is a delay anticipated that would make the case get thrown out, that it wouldn't move forward that way.
Okay, seeing no more hands, I put the matter back to the committee to determine if it shall be carried. So we are now at SPQ 1. Shall it be carried? Or let's put it to a vote. I suspect this is what the issue is. Ms. Clerk?
Madame Romanado?
No.
Madame Lapointe?
No.
Monsieur Watchhorn?
No.
Mr. Mallette?
No.
Mr. Bazan?
Yay.
Ms. Gallen?
Yay.
Mr. Anderson?
Oui.
Mr. Kibble?
Oui.
Monsieur Savard-Tremblay?
Oui.
Yeas pour 5, 5. Nays contre 4, 4.
Okay. The amendment has been passed. Now we're back to CPC 7. Mr. Bazan, do you wish to move?
I shall move CPC 7, and if you want, I can start speaking to it.
Yes, please.
Okay, thank you, Mr. Chair. So the one concern that we did here is if we are going to be moving these investigations over into civilian courts and handing over to civilian police and other authorities, then we need to make sure that there isn't willful neglect and negligence on behalf of those that are doing those investigations, and possibly slowing down the secured evidence in the transfer of that information and testimonies and other evidences over to civilian authorities. We heard that from a number of different people. Heather Vanderveer, in her written submission, says transfers between CAF military police, and civilian crown prosecutors must occur within clearly defined timelines and not weeks, months, or years. She also said we've seen within the military system that things can move at a glacial speed, sometimes when handing over documents, and there always are delays. And so if you're concerned about the Jordan principle and that framework and getting things done within that 18-month time frame, we can't allow the military, police, and other investigative services in CAF to drag their feet. So I think that, Rory Fowler said delay was, in talking about one particular case, the prosecution was stayed for delay, and that delay was directly attributable to repeated delays by the military police in providing portions of the investigation file to the civilian prosecutor. So we got to put some timeline on that, and that's what we're doing with CPC 7.
The debate? Mr. Lapointe.
Thank you, Mr. Chair. I think the intent of this is appropriate and speaks to what we heard. But I'm going to seek clarity from our witnesses here today. Can you tell us if there is a provision that already exists that addresses this?
So yes, there's already a provision under the National Defense Act that create the offense of negligence in the performance of duties. It's the every person who negligently perform a military duty imposed on that person is guilty of an offense or in conviction is liable to dismissal with disgrace from Her Majesty's service or to less punishment. So it's an offense that talk about negligently. Here we're making the link to this provision by naming the provision of section 124, that's the offense, and it's adding an element of talking about willfully that is not covered by the offense itself. So it's suggesting to change the offense, the way to commit the offense under 124. That is a negligent offense. Here we're talking about willfully doing something. Also, when we talk about a military duty imposed on someone in court, it's the prosecution that has the duty to transfer the evidence, to give the evidence to the prosecution, to the defense counsel, or to the accused if the accused is not represented. So here, the amendment seems to suggest that it's on the military police member, where really the duty imposed in the system, it's the prosecution that has that duty. So you could not lay a charge when there's no duty on someone to do something. that's not an offense. So you need to have initially a military duty to do something for it to become something to be considered under 124. So, and in this system, it's the prosecution that has it. And if I can add the third element to that, we're talking about disclosing evidence to the counsel representing the accused that do not propose to cover the case where the person is not represented. So it kind of, the contrary would be that it seems okay if the disclosure is not given to the accused themselves.
All right, so there's a provision in place already. We have a system in place, certainly. And so in terms of checks and balances within that, can you describe to us what are the checks already in place to make sure evidence is handled properly in an investigation?
So it's really when you come in time in court, so when charges have been preferred in the military system or your charge have already been laid in the civilian, that will be on the prosecution to look and give to the accused person or to their lawyer all the evidence that they have related that prove the offense or prove that they have not committed it, to disclose the tape, the statement, and everything. So there's a listing that is done, and everything will be given over. If the defense feel that they have not received everything, they can go to the judge and request for more disclosure also.
Thank you.
Ms. Romanado.
So based on that, I just want to make sure I'm understanding. So this amendment is to ensure that there's no unreasonable or unwilling delay on behalf of a CAF member handing over evidence to the defense. But as you clearly indicate, so obviously recognizing Jordan's principle that time is of the essence, that we only have 18 months to prosecute a case. But what you just said, it's not actually the CAF member that would be sharing evidence with the defense counsel. It's the prosecutor that has the duty to share that evidence. Is that correct?
Yes, you're correct.
So this actually, I don't want to say doesn't make sense, but procedurally it would never be a CAF member handing off evidence to a defense attorney. Is that correct?
You're right. It's in the system, the prosecution will get from the military police, they will get the file or the unit, the CAF member that has done the investigation. They will package everything. It will be listed and pass, and disclosure will be sent to defense counsel if the person is represented, or to the accused, with a list of evidence of listing to make sure that everything that has been given.
Okay, thank you.
So there's clarity in this. The amendment, prefers in the first two-thirds of the amendment to clauses 1 to 3, which is a transfer of evidence from military police or other investigative within CAF to civilian authorities. So it's all the stuff that's going on with collaboration and concurrent jurisdiction that we now have, or returning back through the choice process. But that if it's going to be pursued by the civilian police agencies, then the military police and those on base who have that evidence have to turn it over. You could have, if you want to really remove the chain of command and a local colonel on a base may make the decision, well, this is a friend, we want to protect them, let's make sure that we slow down this process. So that is willful, and willful needs to be punished. And it's more than just negligence, and that's why the wording is stronger. The last part of that is the transfer of information to those that are victims and turning that evidence over to counsel. We have heard over the years of people can't even get access to their files and we heard that as witnesses as well. And so I would just say that we want to make sure that, Elvira Jasperini, when she was here, she said that a lot of things in her file disappeared. So she wasn't even getting all the information from the military prosecution or the military police. So we want to make sure that if that is done willfully, that there is extra penalties for that. That's the purpose behind adding this paragraph 5 to Section 70.2.
Okay, Mr. Mallet?
Thank you. And I'm going to be fairly brief. And as my colleague, Madame Lapointe, pointed out, there are portions of this that are somewhat laudable. But after hearing the witness testimony and seeing that some of these cases already exist under 124 of the National Defense Act, it's redundant. We're duplicating existing provisions that there are provisions in the Act already that punish anyone for not properly delivering custody of evidence or investigative materials. And in the case of Ms. Jasparini, she already has a recourse under 124 of the NDA. So I can't, unfortunately, support this. Thank you.
Ms. Idla, your hand is up. Over to you.
Yes, thank you so much, Chair Ixabota, for recognizing me. I'm just feeling compelled to ask the witnesses who are experts in this system, as I understand it, regarding these types of cases. What kind of, having heard Mr. Bizan's reasoning for CPC 7, which sounds quite important from the victim's perspective, and making sure that the victims are getting the justice that they deserve, and making sure that there's as many avenues for them to have that sense of justice without closing doors. I'm wondering if the witnesses can share with us what training they've taken to be trauma-informed or to understand what the victim's lens is like in undergoing their work, and describe really what kinds of training that they take to make sure that victims' lens is understood within this system. Thank you so much.
One of the big aspects in relation to our office, the Office of the Judge Advocate General, took the steps of ensuring that it's been a couple of years now, but we had a practitioner come in whose role was to take and to teach trauma-informed lawyering to lawyers. We took that training that was presented by the individual whose name escapes me at this time, but a vast majority of our office took the training at the time. It spoke about trauma-informed lawyering in relation to, specifically in the context of criminal matters. So that's one major aspect. Beyond that, we do have obligations to take professional training yearly, continuing legal education, and part of that is ethics relation in terms of how you deal with people that you actually support. Those are the two big aspects in recent time.
I'm seeing no further hands. Shall CPC 7 carry? Recorded vote.
Madame Romanado?
No.
Madame Lapointe?
No.
Monsieur Watchhorn?
No.
Mr. Mallet?
No.
Mr. Bazan?
Yes.
Ms. Gallen?
Yes.
Monsieur Anderson?
Yes.
Mr. Kibble?
Yes.
Monsieur Savard-Tremblay?
Oui.
Yeas pour 5, 5, nays contre 4.
Okay. CPC 7, that's carried. Monsieur Savard-Tremblay, do you wish to move BQ2?
Oui.
Yes.
Okay. Now that you've moved it, I have to state that Bill C-11 amends the National Defense Act by removing the Canadian Armed Forces authority to investigate an offense under the Criminal Code that is alleged to have been committed in Canada, and that it is of a sexual nature or committed for a sexual purpose. The amendment seeks to establish a plan to create an office for the Inspector General for Sexual Misconduct in the Canadian Forces. As the House of Commons Procedure and Practice, 4th edition states in section 16.74, an amendment to a bill that was referred to committee after second reading is out of order if it's beyond the scope and principle of the bill. In the opinion of the chair, the Office of the Inspector General for Sexual Misconduct in the Canadian Armed Forces is a new concept that is beyond the scope of the bill. Therefore, I rule the amendment inadmissible.
Il me fait plaisir de remettre en question votre décision, Monsieur le Président.
I would be pleased to raise an issue with your statement, Chair.
The chair, is that correct?
Yes.
Okay. Okay, over to you, Clerk.
The question is, shall the decision of the chair be sustained? If you vote yes, you agree with the chair's decision. If you vote no, you disagree with the chair's decision. Madame Romanado.
Oui.
Madame Lapointe.
Oui.
Monsieur Watchhorn.
Wait.
Mr. Mallette.
Wait.
Mr. Bezan.
No.
Ms. Gallant.
No.
Mr. Anderson.
No.
Mr. Cable.
No.
Monsieur Savard-Tremblay.
Nope.
Yeas pour 4, nays non, contre 5.
Okay. All right, so BQ2 is up for debate. Is Mr. Salvatore, do you wish to speak to it, or should we proceed?
Alors, brièvement, l'intention.
So briefly, the intention of this amendment is to force the government to create a plan for the Inspector General's office to be charged with dealing with sexual offenses in the Canadian Armed Forces.
Mr. Bazan.
This. I know that, you ruled it out of scope, but I think that this is relevant. We have heard over the years, including from the National Defense Ombudsman, that there needs to be greater independence of the Ombudsman's office, and that could take on the role of having this new office created by having an Inspector General. And most of our allied nations have Inspector Generals to deal with these types of issues, including sexual misconduct within their forces. So I think that having this request for a plan to be tabled within 6 months of the adoption of Bill C-11 is very much relevant. It doesn't create any cost to the Department of National Defense or to the government. So this is, I think, a very clear and simple way to deal with the issue of creating an Inspector General specifically targeted towards sexual misconduct within the forces. Will be supported.
Further debate, Ms. Ramanado.
I'd just like to get clarity on whether or not there is something that is already in place that does this, or is this creating a new administrative that's doing something that is already being done? Just for clarity.
It seems that it would bring duplication from existing mechanism that already look. That was something that was asked from Madame Justice Arbor, and that's something that she recommended against, saying that there were already enough existing mechanism that it could be a waste of resource and create an inconsistent mandate, considering that some aspects are under the Canadian Armed Forces, some other aspects are under the, if we talk investigation, that would be the RCMP and outside prosecution. There's already the ombudsman that have a large mandate. There's the Military Police Complaint Commission that could look at those aspects. And there's also a mandated review that exists under the National Defense Act of the provision that are under the Code of Service Discipline and other part that every 7 years there's a mandatory review of the provision, the application, how they deal with that. So I would offer that it seems to be the same type of mandate that is already looked at by other aspect of the institution.
But is there some element that is not already, there's not already a mechanism for oversight that this would fill in that gap? Because this sounds like a very good provision. If it's already being done 100% by other elements, I can understand that. But is there something that is missing? Because the member opposite put forward something that I think, because we heard that there was an element of oversight that was missing. So is there any gaps that would be picked up by this new administrative body that's currently not addressed in our other mechanisms?
Not to my knowledge. So when there's systems that were created previously, like the victim liaison officer, it was felt that something was required because of some uncertainty of the system. Here we're talking, and if I can add of another organization that we have in the Canadian Armed Forces, the Chief Professional Conduct and Culture, known as CPCC, who is responsible for addressing systemic misconduct and driving the culture change in the Department of National Defense in the Canadian Armed Forces. So I would suggest that it's something that they also looked at.
Go back to testimony we actually heard on this, and I think we all remember Colonel Trapeau, also a professor of law, and he says, as a first step, I recommend creating an Inspector General position. He then goes on, the Somali Inquiry recommended the creation of an Inspector General for the Armed Forces. Instead, Bill C-25 created the Military Police Complaints Commission, the Military Grievance External Review Committee, and it all provided civilian, non-judicial oversight over the Canadian military. Then he said the Ombudsman was separately created by the Minister of National Defense. All of the above organizations report to the Minister of National Defense and not to Parliament. The Inspector General would be totally independent of the CAF, appointed by Governor and Council, and be made accountable to Parliament with broad authority to inspect, investigate, and report on all aspects of sexual misconduct in the military milieu. And Rory Fowler said, while the Inspector General wouldn't deal with discipline per se, the Inspector General will deal with the systemic issues arising from complaints that were brought by members of the Canadian Forces or even members of the public. And Mr. Fowler also said that the Vice Chief of the Defense Staff has studied this on several occasions, and it dates back 20 years, looking at the possibility of an Inspector General. There's a lot of study already done on it. We just have to do it. He said, so. Let's, I think that this is very relevant. This is testimony that supports BQ2. So let's have the vote.
Seeing no further debate, shall BQ2 carry? We'll put it to a vote. Mr. Clerk.
Madame Romanado.
Oui.
Madame Lapointe.
Oui.
Monsieur Watchhorn.
Wait.
Mr. Mallette.
Wait.
Mr. Bezan.
Wait.
Ms. Gallant.
Yes.
Mr. Anderson.
Oui.
Mr. Kibble.
Oui.
Monsieur Savard-Tremblay.
Oui.
Yeas, 9.
Great. BQ2 is carried. Now we're into, I believe, the CPC 8. Mr. Bazan, do you wish to move?
I shall move.
If CPC 8 is adopted, note that NDP 3 cannot be moved. That is, it would create an incoherence. An incoherence would also arise if CPC 5 was adopted, which is the case. So, over to you.
Okay, and just to point out that NDP 3 is identical in wording with CPC 8, with the exception of the number of years for the sunset clause from 3 years to 5 years. So as we heard from testimony that we throughout the study on Bill C-11, that there was a request that this be set in time, but only for a limited amount of time. Just as the Champ said, on the number of years, this is referring to a sunset clause, I hesitate to give a fixed term because 2 years is very short for collecting the data. 3 years might be a better number, but I hesitate to say 3 years because I think the Mandatory Review of the National Defense Act is 3 years. It's a long time if harm is done. So you also heard from Christine Wood said, I support adding a 2 to 5 year sunset clause. Diane Hill Rose said at the same committee, also support the 2 to 5 year sunset clause on this bill. Rory Fowler said, as an alternative, I recommend a sunset clause on these changes. This will empower and oblige Parliament to revisit this policy change and examine its impact. Sunset clause will require collection of reliable and relevant data, which we don't have right now, but it will permit a future Parliament to evaluate the impact of the jurisdictional changes. Also, Afton David said, I strongly advise this committee have external counsel perform this review and perform a legal opinion regarding which clauses to attach to the sunset clause, Section 7, Section 8, and Section 12. That was in her written submission. So we have lots of testimony to say that we put in place the sunset clause. We know, hearing from the Director of Military Prosecutions, that Colonel Kerr is prepared to take back complete jurisdiction over investigations, and as we did also hear from the Provost Marshal General, that the prosecution and the investigation should be left in the control of the military police. So this way we have a window in place, allow for that transition and to collect the data and to make the determination if this is going to work or not. Now, we may find out that when we start having more and more cases go in the civilian system that it, either the Jordan framework is going to impact it and we're going to have a lot of cases thrown out, or we're going to see a lot of cases that the civilian system will not want to get bogged down with because their system is already overloaded, as we heard in testimony, and do not think that there's a high probability of success in the prosecutions, and so they're going to not recommend proceeding in the civilian system. So for that reason, I believe that sunset clause is important.
Thank you, Mr. Pazan. Mr. Ramanado.
Thank you, Chair. Actually, it's very rare that I'll say this. I actually agree with my colleague that I don't think 3 years is sufficient in terms of collecting data and to seeing whether or not the application of this is working. I believe the National Defense Act is reviewed every 7 years, but I'm just going to check with the experts here what they would recommend if the National Defense Act is reviewed every 7 years. Is this long enough, a 5-year provision? Is that long enough to be able to get the data that we need to verify whether or not that this is working or not? I just want to get their opinion on this.
So the National Defense Act, the provision that already exists, are 7 years. And what we have seen is that depending on the time, because there's a reset clause when provisions are not amended in the meantime or have just been amended, it gives another period of time that we call like the reset clause, that if there's any amendment that are made by and pass up to royal assent, there's a 7 other years to look at the provision, because it had happened in the past where amendments have been made previously and the period of time was not necessarily there and didn't give enough time to look at the usefulness or the change or the application to have enough data to know how the system works if it gives a certain period of time.
So would 7 be an ideal number for you, or is 5? I think 3, I agree with my colleague. I think 3 would not give us the information that we need. I believe that the interim directive was put in. The interim that was put in in 2021. We're starting to see some data now. But I think I'm just curious from your perspective, is 5 enough? We're talking about CPC 8, which is 5.
I understand from
3.
The provision is that at the end, so there's a period of time to look. There's possibility to have a resolution to extend it for the same period of time. But anyhow, at the end of these, if there's the resolution, the addition of these 2 periods, we're back to what the NDA reads today, and all the amendments that have been proposed of consideration victim, and all of that. That's not going to be applicable anymore. We're going to be back to the concurrent jurisdiction the way the National Defense Act is written today. And with the different amendments that have been passed previously, for sure there's some misalignment in the provision that we read right now in front of us, considering the changes that were done under Clause 7 and changes that are done also under Clause 8. That's kind of, there's a misalignment in the reading of the provision itself with the other proposed amendment just that we went through.
So I know that, as I mentioned, we put in the interim directive in 2021. We're now 2026, so it's about 5 years now, and we're starting to see the data. And I know I would be comfortable with a 5-year versus a 3. And I think that in order to make sure, if you think about the number, how long it takes to process a case, and if we have the question of the concurrent jurisdictions and the moving around, that could happen. I don't think 3 years is sufficient, in my opinion, and so I will leave it at that. Thanks.
So any further debate? I mean, we have, Takara?
Sorry, I would just say just two things. So Section 273.601 of the National Defense Act already will look at the provisions 7 and 8. It's a mandated review that's done independently. That was the review that Justice Fish did. So there will already be a review of these at the end of 7 years. So that's one point. The other thing for consideration is, because it requires a resolution of the House to actually carry on so it doesn't sunset, if there was an election period or prorogation or under the Caretaker Convention and there's no resolution possible, this would just go away at the end of that period of time. So it's just something to consider in relation to what's ongoing and at the time.
So Mr. Bazan.
Just in response to that, so 7-year review, it takes place when? 7 years after C11 has passed, or 7 years since the previous bill had passed, when we brought in the Victim Bills of Rights?
So the way 273.601 is written is that the next mandated review, independent review, is required to be tabled in the House 7 years after the previous one. So 2021 was Justice Fish, would be 2028. However, there's a reset clause that if there's an amendment that flows from one of those independent reviews, it resets to 7 years from the date of royal assent in order to provide the time for the system to actually function and to actually see what the outcome of that actual those amendments were. So it would be 7 years post Bill C11 receiving royal assent that the next iteration would be due.
Continue on that line then, because we did hear from witnesses to limit that. 7 years is a long time, especially if it's not working, especially if it's creating more harm to the victims of military sexual trauma. And Justice Deschamps, contrary to Justice Fish, but she said at committee here that 5 years or 7 years is a long time if harm is done. So less is more in this case. So I recommend we go ahead with the 3-year sunset.
You recommend what, sorry?
We go ahead with the 3-year sunset as it's in CPC 8.
As opposed to the 5?
Well, it's 7.
Or the 7, yeah.
Well, we're saying 8. Well, we're saying 3 is what we're saying in 8. Yeah. And I think that, Justice Deschamps felt that 5 years is too long, especially if it's not working. So this requires a mandatory, that review, and it happens within 3 years, and if it's not working, we just let them expire.
Ms. Romanado.
So I'm going to, just based on what Lieutenant Colonel McMillan mentioned, in 3 years' time, 3 years after royal assent, we might actually be in an election if the House is in an election period and the motion cannot be put forward before the House to continue. I'm just thinking about the timeline, so I was just going to check and see if the colleague I know that the NDP put forward a separate amendment that's very similar, but I think given the fact that there will very likely be an election in the next 3 years, the next scheduled election is in October 2029, that the 3-year might be too tight. So I'm just asking if the colleague across the way would consider a 5-year. Now, I agree maybe 7 is too long, but would he agree to a 5-year?
Go for it. 4.25? Go for it.
I mean, I think what our colleagues are saying is, before we move a sub-amendment to the amendment, which is the NDP, pretty much there, do we want to proceed that way, or are we going to just spin our wheels? Mr. Raminato?
Didn't the witnesses recommend 5? The sunset, yeah.
Again, just on that, Christine Wood said 2 to 5. Diane Hill Rose said 2 to 5. Justice Deschamps said, she says 3 because 5 is a long time if harm is done. So if you're willing, I'll go for it. Go for it. 4. I think based upon Justice Deschamps, it said that 5 was too long. Plus, you know, and I'll just say this.
Monsieur le Président, je vais proposer
Chair, I want to propose a sub-amendment. Number 4, yeah.
Well,
Can you?
Sorry, 4 years.
I can't, but you can. But just. Cat?
Just give me a moment. I want to check on a particular item. Is there a conflict with? Just for clarity, if I may ask the witnesses a question. So we already have something that says 7 years, right, in regards to the Defense Act. By making this amendment to 3 or 4 or 5, is there a conflict thereafter?
Conflict. So what is proposed is a review of these provisions so that the 2 review would happen. So if after the first period there's a resolution proposed and passed, so that could extend for another, and I'm not sure at which number, but the addition of the same period twice. So at that end, we're back to the way the National Defense Act reads today. There's no way to protect or come back or maintain those provisions after that period of time. If that's the intent of a committee at that point, a bill would have to be proposed and reintroduced and redo all the amendment that your committee is doing right now. Sorry?
Expired after 3 years.
They will expire. The way it's listed, it's the addition of the 2, and at the end, there's no way, the way we understand the way it's proposed and written, it's the end of it. There's no way to keep them. So if it works and a recommendation would be to keep them, another bill would have to be tabled and go through all the steps up to royal assent to maintain those provisions.
Bazan. And I am sensitive to time, so.
I'll try to be quick here because, you know, I
Mais
think
Monsieur le Président, est-ce que moi, juste savoir...
Mr. Chair, if I can just know, are we going to deal with my sub-amendment here?
Je vous ai fait savoir que je voulais...
So I said that I wanted to bring forward a sub-amendment, and I get the impression that that was not heard or ignored.
I didn't hear it. I'm sorry, Monsieur Salatamble. So we have Mr. Bazan, then I'll go over to you at that point.
Je l'avais avancé avant. J'avais avancé mon sous-amendement.
I think I had actually presented mine earlier, like before you were asking the other questions. So I think we should deal with mine first.
By all means, proceed.
4.
4.
We're asking for clarification that you're touching all the touch points for the matter at hand. Is that correct?
Donc, Monsieur Savard-Tremblay, je voulais juste confirmer.
So, Mr. Savard-Tremblay, I just wanted to confirm that at 70.41 in French, it says taking effect at the end of the 3rd anniversary, and you want to change that to 4th anniversary. Is that correct? Okay. And furthermore, at 4.1, it says, and that specifies the period of the extension, which may not exceed 3 years. You want to change that to 4 years as well. Is that correct?
Then it would be 70.41, paragraphs 70D to H and section 70.1 to 70.3 cease to have effect at the end of the 3rd anniversary on the day on which the Military Justice System Modernization Act receives royal assent, and last before the end of that 3rd anniversary. So both of those would change to 4th anniversary. And then in 70.44, it would change, specifies the period of the extension which may not exceed 3 years. That would change to 4 years. C'est ça? Merci.
We have a sub-amendment by the BQ, as clarified. For the debate, Mr. Bazan, you want to speak to that?
Good with it.
Anyone else? Can we put it to a vote, please? Should the sub-amendment carry by the block?
Madame Romanado? Madame Lapointe?
Oui.
Monsieur Watchhorn?
Oui.
Mr. Mallet?
Ouais.
Mr. Bazan?
Oui.
Ms. Gallant?
Yes.
Mr. Anderson?
Oui.
Mr. Kibble?
Oui.
Monsieur Savard-Tremblay?
Oui.
Yeas pour 9, nay contre 0.
Okay, we're back to CPC 8 sub-amended amendment. For the debate on that matter, or shall we go to a vote? Let's go to a vote.
Madame Romanado?
Oui.
Madame Lapointe?
Oui.
Monsieur Watchhorn?
Oui.
Mr. Mallet?
Yes.
Mr. Bazan?
Yes.
Ms. Gallant?
Yes.
Mr. Anderson?
Yay.
Mr. Kibble?
Yes.
Monsieur Savard-Tremblay?
Oui.
Yeas pour 9, nay contre 0.
So that makes clause 8 carried. No other submissions made will qualify because of the coherence matter. Just a moment. Now that brings us to, before we wrap up today, let's wrap up clause 8. Shall it be moved? Shall it carry? On division, on recorded vote, we just carry. Okay? Okay, that brings that to clause 8. I'm just trying to see where we're going to be at by tomorrow, because I think, as you know, time is coming to an end. We have it until 1 o'clock. So I'm asking the committee for agreement to adjourn, or do you want to?
Stay on this one.
Cherry, ton microphone, s'il te plaît.
There's 1 minute left, unless you guys are supporting it.
On va attendre pour mercredi. J'ai dit parce qu'il y a seulement 1 minute qui reste.
I said since there's only 1 minute left, should we wait for Wednesday to start the discussion on the new amendment? That's all I was going to suggest.
Okay, with the community's agreement, I adjourn the meeting until we'll see you on Wednesday. Meeting adjourned.
Thank you, everyone.